What's up, Coach Baker?
What's going on? All right.
Not as enthusiastic today. Normally you got a little more energy.
No, I'm running behind. Like, I'm gonna end up always running behind in your class.
It's one of those days.
No, I mean, I recorded for my my AP class last night in Kansas, and Kansas then just took a dump on me and refused to, like, they got a lovely little message from Kansas. It's like, sorry, we messed up. And then like an hour worth of work was just gone. Yeah. So now I had to teach the second period, and I'm trying to convert that while starting another Zoom to teach y'all. So I hope that works, but I'm not going to hold my breath because I assume that it won't. And whatever, I can't care anymore. I can only do so much in life. So I'll do what I can do to the best of my abilities and then move on. All right, we're going to talk about civil rights today. We already talked about civil liberties. Civil rights and civil liberties are different. You need to understand that. Civil liberties pertain to the individual. Civil rights pertain to the group. Civil liberties are things that that protect you from governmental overreach or your individual behaviors. Civil rights are protections against discrimination, and specifically governmental discrimination, because individuals are allowed to discriminate against you. They just are. Right? We can't really stop that. Right? So again, civil liberties, limitations on government's ability to interfere with the individual. Civil rights are rules governing sort of the political process and the treatment of citizens. Okay. Again, your liberties, things like freedom of speech, freedom of worship, things that you can do, whereas your rights are indicative of groups. And so one is the Equal Protection Clause of the 14th Amendment. That pertains to civil rights because we're going to treat people equally under the law. The Due Process Clause of the 14th Amendment pertains to civil liberties because your liberties can be removed, right? They can be limited. In order to limit your civil liberties, though, we have to follow due process, which is just a set standard of like regulations. Obviously, we can't talk about civil rights without actually talking about slavery, because obviously slavery is a significant issue as it pertains to this. Okay, so slavery is obviously a form of racial discrimination. It existed in the United States for roughly 250 years. It's obviously not in sort of keeping with the founding ideals, right? Like we talked about sort of our ideals in terms of like what we believe in as a democracy, as a government. But this is obviously a little bit different, right? Civil rights for women. Obviously, women did not have civil rights either. They did not have things like voting rights or things of that nature. They didn't have the right to own property. There are all sorts of things that didn't happen for women up until 1920 when they got the right to vote. But they're another sort of suspect class. And we'll talk about the difference in those classes over time, right? So obviously no issue has been more divisive than slavery, okay? And the ramifications of it have sort of been long felt. I'm sure some of you are aware of the 1619 Project from the New York Times that sort of tries to delve into the history of slavery. I will say I'm not necessarily of the same mindset as a lot of scholars as it pertains to slavery. And I actually adamantly disagree with some of the conclusions of the 1619 Project, right? So the 1619 Project basically tells you that the wealth of America is based upon slavery. If that were actually true, the southern states should be where all the wealth is, because that's where all the slaves were. And that's not accurate, right? Our southern states are actually generally our poorest states. Okay. That being said, slavery was obviously a significant economic issue. And so when you go back and you look at some of our founders and some of the ideals and the concept of all men are created equally, obviously we did not treat blacks equally. Slaves were not treated equally. But some of our founders, even some of our slave owning founders, I think understood sort of the ramifications of slavery and how wrong it was. They simply didn't have the economic means to eradicate it. And the abolitionist movement is a way to stop slavery. Obviously, it becomes its own political party. It's aimed at trying to help blacks obtain equal protection under the law, right, or basic civil rights. And out of all of this comes the Dred Scott case. Actually, this is probably a decent place to stop and tell you. You know, you've got your next essay due in 2 weeks, right? Mm-hmm. Are y'all aware of that? Mm-hmm. You know what the essay is? Mm-hmm. You're writing a dissenting opinion on a Supreme Court case. Okay? So civil rights and civil liberties is sort of what we're dealing with here. You're going to write a Supreme Court case. You're sort of a dissenting opinion, meaning why the court is wrong. Okay? So with Brown versus Board of Education, just so you understand, so Dred Scott, right? Dred Scott is taken to a free territory. His master, his owner, dies, and he sues for his freedom. The Supreme Court says no, and it's a little worse than saying no. It's not that the Supreme Court determines that he's still a slaver, that he can't be granted his freedom, but rather the Supreme Court rules that he's not a human being, he's not a citizen, he has no rights to stand, no standing to sue, and then it would be sort of the equivalent of your vacuum cleaner trying to sue you today. Okay, yeah, like that's how sort of catastrophic it is. So this is a sort of terrible concept. But one of the positives that comes out of this, that doesn't work, huh? I guess because I'm sharing my screen. One of the positives that comes out of this is the 14th Amendment actually creates, there's a citizenship clause in the 14th Amendment that creates a definition of who is and is not a citizen. And so it actually is going to overturn Dred Scott. Right? It overturns the Dred Scott case because now Dred Scott is a citizen. He is a human being. He has grounding to stand, standing to sue, grounds to bring about legal recourse. So your essay that's due in 2 weeks is going to ask you to write a dissenting opinion. Okay, but here are the stipulations. 1, you cannot write a dissenting opinion on a case that has been overturned. Right? So obviously we recognize that Dred Scott's decision is wrong. Right? It is terribly wrong. It has been overturned with the 14th Amendment, so you cannot write about this one. Okay? The only other stipulation that I have is in which cases you can or cannot write about. You cannot write about Roe versus Wade. Okay? I don't want to hear your moralistic argument as to why abortion is wrong. All right? Because ultimately you're going to fail to understand sort of the actual legal ramifications of the case. All right? But you're telling me why the Supreme Court is wrong. You will write it as if it is today. If you pick a case like Wickard v. Filburn from 1944, which in my opinion is a poorly decided case, you write that case as if it's 2020, right? You write the opinion as if it's 2020. Okay? If I were to do this assignment myself, I would write about Reynolds versus the United States, which was decided in 1879. I'm writing that case as if it is 2020. Got it? Okay. The women's rights movement, one of the things that you'll notice with civil rights is that they are sort of linked to one another. So when civil rights for African Americans happens, civil rights for women attempts to happen as well. There's some variation in the sort of general success, right? But out of abolition and sort of the anti-slavery movement, there is what I refer to as first wave feminism, which is 1848, the Seneca Falls Convention, where women basically laid out their own sort of declaration of independence or declaration of rights, where they're basically demanding the right to vote and sort of equality under the law with men because they did not have that. Civil War Amendments 13, 14, 15th Amendment. 13 abolishes slavery and indentured servanthood. 14th guarantees equal protection under law, guarantees due process under the law, guarantees citizenship. 14th Amendment is actually arguably the most important amendment to the United States Constitution today. And then the 15th Amendment guarantees voting rights for black men, only the men. After the war is over, we have Reconstruction. And again, some of this is U.S. history, so I'm going to breeze past this, right? But you do need to understand with sort of the general state of civil rights in the United States, there were instances in which blacks had more civil rights, or they were, not that they had more civil rights, they were able to exercise them, right? That's really the thing, because after the 15th Amendment, black men have the right to vote from 1865 until the present, right? But ultimately what happens is during Reconstruction, when you had the Republican Congress controlling Reconstruction, and you actually had military Reconstruction, meaning the United States military, the Union Army remained in the South and oversaw sort of the implementation of law, right? Basically martial law, right? You had opportunities amongst Southern black men to exercise their newfound civil rights. Right? When Reconstruction ends with the Compromise of 1877, that basically ends, right? And it's not that black men lose their civil rights, just Southern Democrats figure out ways to prevent them from exercising them, all right? And there's a wide variety of ways they do that, but you should know Jim Crow laws, right, or black codes as being the most prominent method of doing that, right? Near the end of the 19th century, we do create something called the separate but equal sort of doctrine. The Supreme Court codifies it in Plessy versus Ferguson in 1896. It says separate but equal is okay, right? And so when we look at civil rights, we're basically saying that it's okay to be segregated, right? So long as the accommodations are relatively equal, right? So when you look at like public busing in the South, right, blacks and whites got on the same bus, whites sat in the front, blacks sat in the back. So maybe according to the courts prior to Brown versus Board of Education, that's okay, right? Because it's equal, it's the same bus, they just did separate seats, okay? So conceptually, this is what the court originally comes up with, okay? Ultimately, what we sort of realize, and water fountains are actually a really good example of it, right? Because you can find some pictures in which basically the water fountains are like almost right next to each other, right? So it's the same pipes bringing the same water with the same amount of lead and chlorine and calcium and everything else that's in your water, right? In which case the courts say, well, that's separate, right? Because we have two different water fountains, but it's equal. And because ultimately everybody's getting the same water, the same temperature, same opportunity, yada, yada, yada. Okay? Eventually what we're going to realize is that the very act of creating a separate water fountain for somebody, okay, creates the implication that they are less than, right? That they are somehow inferior. And it doesn't matter if the same water is coming through the same pipes out of two different water fountains. By simply telling somebody that they are not welcome to use one of those two water fountains, you are telling them that they are less than, which ultimately becomes the problem. Okay? One of the early ways that we tried to accomplish this was with the NAACP, and so it's the National Association for the Advancement of Colored People. It's an interest group, right? We covered interest groups already. Okay? They're going to use the court system in order to put some political pressure on the legal system and the legislative system and the laws that are actually being written, right? Women will try to do the same thing. They do create national organizations as well, like NOW, which is actually the National Organization for Women, right? But that organizational aspect becomes relatively key. Okay. Now, by the time we get to the sort of post-World War II era, and again, so I told you that there's sort of a piggybacking effect on civil rights, right? Like when Black people have civil rights gains, a lot of times women try to sort of piggyback on that and get some gains as well. I will tell you another thing that creates opportunity is war, right? So women get the right to vote coming out of World War I, because obviously the men went to war and the women then had to go to work, and they proved that they were basically every bit as capable as the men of doing all manner of things. Okay, and so as a result, they get the right to vote. Right, Black men in World War II, not that they hadn't in many other wars prior to this point, right? But Black units basically proved that they're equal to other units, that they have the same sort of economic or same sort of like work ethic and desire and drive and success and all of that stuff. And so that becomes sort of a catalyst for the civil rights movement. Right, Truman actually begins this process following World War II. He's going to I think it was in 1948. Truman desegregates the military, right? So even all the way through World War II, we basically had Black units and white units within the military, and Truman is going to get rid of that. And that brings us to 1954, right? And basically, we've had enough sort of litigation against some of these concepts that we begin to realize that the idea of separate but equal isn't really fair. Okay, so it begins actually. I mean, Brown versus Board of Education in 1954 is the case that gets all of the sort of publicity about this issue. But there's actually a 1950s case here in the state of Texas that goes all the way to the Supreme Court in Sweat v. Painter, in which a Black man applied for the University of Texas's law school and was denied admission solely because he was a Black man, right? Now, under the concept of separate but equal, right, had there been a Black law school, right, then you would have just gone there and separate but equal is okay. Except there wasn't a Black law school, right? So Prairie View A&M, which is a HBC, right, a historically Black college, they didn't have a law school at the time. So this man had no recourse to be separate but equal. Even then, once they create a law school, the courts are actually sort of in favor of saying that it's still not equal, right? Because if you go to law school all by yourself, right, and you have one professor, how good do you think the quality of your education is? Right? When you look at education, and specifically how the court has ruled as it pertains to education over the course of time, okay, diversity within education is actually celebrated and promoted. Okay? We have had a number of cases. One of the more recent ones, again, is from here in Texas. Some little girl named Fisher sued the University of Texas about a decade ago because she didn't get into UT. Poor little thing, she had to go to LSU, right? But she didn't get into UT because she was white. And there were some minority people that got in over her, even though she was more qualified, according to her. And colleges, I will tell you, colleges absolutely look at race and gender and things of that nature in terms of creating admissions policies. Okay? And the courts are okay with that. The Supreme Court is okay with that. So long as race is not the only factor, it absolutely can be a factor in admissions. And the truth of the matter is we have something, there's a concept called the marketplace of ideas. You ever heard that term? The marketplace of ideas is an essential concept in terms of like democracy and learning and things like that. The wider a variety of people that you are exposed to, right? The larger the number of ideas that exist in the marketplace, and that ultimately is beneficial to your education, okay? I'm telling you, I think we talked about it when we talked about media, right? Do not only ingest media that already aligns with what you believe, because you won't learn anything that way. Okay? If you are, like where I used to teach in North Carolina was a historically black high school. Okay? Like it was desegregated high school for Greensboro County prior to desegregation. When I taught there, like 8 years ago, okay, it was 98% African American. Okay? And a large number of my students wanted to go to school at North Carolina A&T, which is a very good school. It's an HBC that was literally like 6 blocks from the high school. Okay? I tried to talk every single one of them out of it. Because there's no diversity in thought there. You're engaged in the exact same sort of conceptually what you've been engaged in. Okay, hold on. Baker. Mm-hmm. Hey, do me a favor, because I'm zooming and teaching right now. Can you just forward it to me, and I'll call you during advisory. All right, thanks. Okay. But yeah, so that concept of marketplace of ideas and your ability to be exposed to new ways of thinking is absolutely essential. And so Brown versus Board of Education realizes that separate but equal creates inherent inequalities. Absolutely inherent inequalities. And that doesn't even stem, like that doesn't even really take into account the fact that if you were to look at, and hopefully you had a U.S. history teacher that showed you the differences, right? But have you ever seen the difference between a black schoolhouse in 1950 and a white schoolhouse? Like, have you seen photos of the difference? Okay, if you haven't, a white schoolhouse would actually look fairly similar to this room, right? Take away this technology stuff, right? Make the whiteboard a chalkboard, right? Instead of a dry erase board, a chalkboard, right? But otherwise, you have some bookcases and some books and stuff like that, right? A black, you have desks and chairs. A black schoolhouse, the schoolhouse in its entirety. A lot of times it was one single room, right? For kindergarten through like whenever you dropped out to go get a job. Everybody's together in one room. You might have had one long bench. No textbook, no books, no bookcases, no chalkboard, right? Like if I showed you a picture of some schoolhouses in 1950, you might think that we are looking at 1850, all right? So it's absolutely not equitable, right? And we realize that. And Brown versus Board of Education applies a strict scrutiny test in terms of when a governmental behavior is discriminatory. So if the government is going to discriminate, and understand that the government can discriminate, they absolutely can. Okay? There are some instances in which government discrimination is deemed to be essential or necessary, or it provides for the common good. But in order for that to happen, the government, the burden of proof falls upon the government to ensure that what they have done is necessary. Okay? Most states, most of our southern states, initially refused to abide by Brown versus Board of Education. In fact, it really isn't until the 1960s. It takes like a decade before we begin to desegregate schools. All right. That being said, right, we ended jury segregation, which is segregation by law, but that doesn't end de facto segregation, right? So obviously we don't have segregation today, right? Not by law, at least. Yet the school I taught at in North Carolina was 98% black. Why? It was in a black neighborhood, right? That's de facto segregation. And that still goes on today. If you don't believe me, go to any major city in the United States. Any major city, and you'll find like a Chinatown neighborhood. You'll find a Little Italy neighborhood, right? In New York City, Hell's Kitchen is the Irish neighborhood. Like, I don't even know why Irish and the Italians need a different neighborhood from one another, right? I mean, they're both white and Catholic and have like 47 kids. And so Brown versus Board of Education aims to end school segregation. It aims to desegregate. Eisenhower eventually has to send in U.S. troops in order to sort of accomplish this concept. And there are some some significant drawbacks. So there's some issues as to what is or is not permissible as it pertains to all of this. There's actually a second Brown decision, Brown versus Board of Education Part 2. But after we desegregate schools, we're also going to go through and try to desegregate a whole bunch of other things, right? Like Rosa Parks and a Montgomery school bus boycott, the Montgomery bus boycott, the like lunch counter sit-ins, Woolworth's lunch counter is one of the early ones that starts in February of 1960. It was actually, again, right down the street from where I used to teach in North Carolina, right? What is it? Yeah, causes and effects. So the Civil Rights Act was passed in '64. Again, the courts have done things, but there's been a significant sort of pushback among southern states. And so Congress passes a whole bunch of stuff that sort of strengthens voting rights and says the public accommodations can't be segregated, schools can't be segregated, you can't discriminate in hiring or firing or things of that nature. But again, it's an attempt at governmental behaviors, right? Can't discriminate on school boards. Okay, we get Title 4 and Title 6 that talk about having the national government sort of take over, and then having governments withhold funding in the event of segregation still being practiced. And so all of this is just indicative of sort of the governmental response that is necessary in order to right this. And I think, and I'm speculating now, but I would speculate as to say that even like libertarians or people that believe that the government shouldn't get involved in things would argue that a lot of these provisions in the 1960s are absolutely necessary because state governments were ultimately the ones that were responsible for all of this sort of legal segregation and legal limitation to the rights of blacks in the South, right? Further protections, right? When we look at busing, we see things where you desegregate busing, you limit racial quotas, or no, sorry, it allows for quotas, meaning that certain jobs had to be filled by a certain percentage of minorities, right? Title VII outlaws job discrimination, which we create the Equal Employment Opportunity Commission as well. And in '65, we passed the Voting Rights Act. I'm going to tell you, voting is actually, and has been deemed to be over the course of time, a state issue, right? States were in charge of voting. However, the Voting Rights Act of '65 basically says if you have a state that has a history of discriminating, of disenfranchising people that should be allowed to vote, the national government can come over and take it over, right? It gets rid of literacy tests, and y'all already did a thing on literacy tests. We eventually passed the 24th Amendment that bans poll taxes, right? A poll tax is basically a payment that you have to make in order to vote. And now, to be honest with you, this is something that I think will become another issue because I think that you're going to see some legal challenges to this coming down through the court systems here relatively soon, right? If you are 18, you know what it takes to vote? You know what you have to have in order to go vote? You have to have an ID. There's actually like 7 different types of identification that are permissible under Texas state law. One of them is a military ID, right? So if you're in the military, you get an ID for free. The other 6 you got to pay for, right? Like how many of you have a driver's license? How many of you got your driver's license from the state of Texas for free? Right? We had to pay for that. If that's a requirement in order to vote and you have to pay to get it, did you have to pay to vote? Possibly. Quite possibly. Which I think you can make an argument that that is a poll tax. Okay. Shelby County v. Holder, right? This overturns some of the Voting Rights Act. If you paid attention to the confirmation hearings for Amy Coney Barrett, that was something that came up. Because like I just mentioned, you have a whole mess of states that have passed voter ID laws, or at least some form or manner of voter ID laws. Housing discrimination. Housing discrimination obviously happened. Minorities were prevented from buying homes in certain neighborhoods. Over the course of time, we've had various pieces of legislation that have tried to limit that, right? Because we want sort of this concept of redlining. And redlining is basically a financial way of trying to increase segregation through the use of banks, trying to stop that. Marriage, as it pertains to interracial marriage, right? Loving v. Virginia is a Supreme Court case from the 1960s that basically says interracial marriage has to be legal, right? And there's your loving couple that challenged that. Okay, the Equal Protection Clause. Again, the Equal Protection Clause is part of the 14th Amendment. You should recognize, and if you're looking at the 14th Amendment, the two clauses that pertain to civil rights and civil liberties are different. Equal protection, right, is civil rights. Due process is civil liberties, right? The easy way to remember that is, what is the civil rights movement about? About equality, right? So that's equal protection. Okay. Again, there's some differences because we don't want perfect equality. We talked about that when we talked about our ideals and our ideology. We don't really seek equality in the United States as part of our political ideology. We don't want equality. Equality is communism or socialism. And the only way to actually achieve that level of equality is basically to drop everybody to the lowest common denominator, right? And that certainly doesn't sound like fun. There's a Kurt Vonnegut short story that does a fairly good job of explaining that. And I forget the name of the short story, but you could ask your English teacher. I'm sure Sydney knows. So the lowest level of scrutiny is just a rational basis test, right? So is there a rational reason for the discrimination? Intermediate scrutiny, it has to serve an important government interest, and then strict scrutiny, it has to support a compelling government interest. There has to be no other way to achieve that interest, and so it becomes significantly harder. Strict scrutiny generally applies to like race and ethnicity. Intermediate scrutiny applies to things like gender or I guess gender ideals or sexual orientation, right? The lowest level here is things like, I mean, you know what the most common form of discrimination from our government is, right? Age-based discrimination. How many 10-year-olds do you know that are allowed to drive a car?
I agree with that. Like,
How many 19-year-olds do you know that are allowed to drink alcohol? Right? Like, those are age-based discrimination. Like, understand that. And is there a rational reason for it? Like, is there a rational reason that you can't drink alcohol? There absolutely is. It's a rational scientific reason. Your body is not fully developed. Your liver is not fully developed. And introducing the toxins of alcohol to your underdeveloped liver, right, is actually significantly worse for your liver. Like, one beer is significantly worse for your liver than what it is for my liver, right? Because my liver is fully developed. Okay? That's that rational basis test. That's the idea. Okay? Gender discrimination, we have the Equal Rights Amendment, right, or the ERA. It passed through Congress, but it ultimately fell a couple states shy of ratification. I'm going to be honest with you. I don't see a need for it. Yes, it basically says that you cannot discriminate on the basis of gender, but to me, that's implied in the 14th Amendment, right? I think women are already protected under the 14th Amendment as citizens and whatnot. Okay? All right. Transgender rights, this is something that's become more apparent or more relevant today as LGBTQ rights have been more at the forefront. of our sort of struggle for civil rights within the United States. So again, Title VII there does make it illegal to discriminate on the basis of gender, which obviously if you're transgender, then your gender sort of falls into that, because sex, I will say this, a lot of the times in a legal understanding, sex and gender are sort of interchangeable. I personally would argue, and this is where you'll sort of learn that I'm a bit of a textualist in terms of the Constitution, meaning I want to follow like the actual written word. To me, sex and gender are not the same things. And so to provide protections against sex discrimination does not necessarily provide sex discrimination for gender related issues. But our government has basically extended it and treated it as if they were one and the same thing. Equity in education, Title IX. If you actually go outside of this door right here, you'll see some Title IX flyers that are on the wall of this hallway. Title IX is what tries to create some sort of equity in terms of education, specifically as it pertains to women. There used to be a significant amount of gender discrimination in schools. There actually probably still is a significant amount of gender discrimination in schools. Although interestingly enough, I can cherry pick data that tells you that men are actually discriminated against in schools now. That we teach in a manner that is more conducive to female learning styles. Believe it or not, so when we go back to like college and like the diversity in college, anybody know what the easiest thing to get into college as is? Like if basically if you have different standards for race and gender and whatnot, right? What is the easiest group to get into college? Anybody know? Native American men. They go to college at the lowest rate, and then black men, right? Who is it hardest to get into schools for? Like which group of our population goes to school at the highest rate, goes to college at the highest rate, you know? Asian women, right? In fact, colleges in this day and age are almost 60-40 female to male, okay? Which is why I could make arguments that we're actually discriminating against men now. I don't know how well that argument would hold up, because like I said, I'm going to be cherry picking some data in order to try to achieve that argument. With this, we also end sort of public gender-specific schools, right? Again, public, has to be a public school, okay? So VMI, the Virginia Military Institute, is publicly funded. They had been an all-boys school up until 1996. Sexual harassment falls under civil rights. In fact, you could really put what's called a hostile work environment in that concept, because if you were to work somewhere and they were to continue to use the N-word, right, like that's a hostile work environment, and that is deemed discriminatory, right? Even if, let's just say for the sake of argument, you work at like McDonald's, right, and the other person that also takes orders at McDonald's, like not your boss, by any stretch of the imagination, right, but they keep using the N-word all the time and they make you uncomfortable, okay, that's still deemed to be discrimination, and like that McDonald's and those managers could actually be held liable for it, even though they're not the ones doing it. Same concept like sexual harassment. It does not necessarily have to be sort of quid pro quo, where your boss is like, hey, you do me this sexual favor and I'll give you a promotion, right? That's quid pro quo. And that's obviously not acceptable. But the concept of a hostile work environment is a part of sex discrimination as well. And that's still something that's sort of challenged and difficult to deal with today. Obviously, you've had a number of cases brought by women in the military, you know, because the military sort of functions differently, and it's a good old boys network and whatnot. Equality in employment. So women have fought for equal opportunities in employment. For the most part, they do have equity in terms of job. So they do. There are not very many professions now that are not open to women. That doesn't mean that women make up the same percentage of the workforce as men do in a wide variety of positions. But it simply means that there are not very many positions in which women are no longer allowed. Even when you look at the military, women are now allowed in combat positions as a result of the Obama administration, which they had not been prior to this point. One of the things you will hear when you talk about equal protection and civil rights as it pertains to women is the idea of the pay gap. I'm going to be honest with you. Again, depending upon how you cherry pick your information, you can either find a pay gap between men and women, or you can easily explain it away, right? For instance, if you look at my wife and I are both teachers. We've both been teaching for 8 years, right? So we have both been teaching for the exact same amount of time. She's at Poly Ryan. I'm here at George Ranch. I make more money than she does, right? Why do I make more money than she does? Because I have a master's degree. She does not, right? I teach dual credit. Obviously, she does not. I coach. She does not, right? So when you take those various factors into account, my higher level of education, my additional work hours, right? Like, that's why I make more. And so you can explain it away that way a lot of times. Again, I'll make way more than my wife this year. Like, it won't even be close, because my wife will miss 3 months of work in which she will not be getting paid when she has the baby in December, right? So again, if you were to take that data and be like, well, they're both teachers and they were both full-time employees this year, and the husband made $70,000 and the wife made $30,000, and that's a huge pay gap. Yeah, I also didn't take 3 months off, right? And I also work weekends and nights, and she don't. Right? So I think this gets us to the end of it. This just gives you some data, and so we'll flip through these relatively slowly so that you can see them. But yeah, there you go. So you can. Oh no, go ahead and go.
I need to use the restroom like badly. That nap I just woke up.
Of course you do. I'll do that during 7th tonight and add it. It's not much. I mean, obviously, what? It's more than that, because it's basically the inclusion of like 5 more groups, like Native Americans, Hispanic Americans, Asian Americans, gay, and then like disabled, right? So I'll go through that as well. What's up? Is there no author to this?
No.
Okay. Pull the internet up. Pull that resource up.
The cool part about this is that since my dad works in, him and his brother, well, his brother owns a company that like rehabilitates veterans, and so he writes like a lot of grants over this. So I kind of like.
Okay, so this should be where we left off, and then I'm gonna add these 2 videos together, and hopefully it's one straight shot. So looking at civil rights as it pertains to Hispanics, Hispanics are obviously one of the they're now the largest minority group. They are a protected or a suspect class now. So they do constitute as that. There's been historical discrimination. There's been a handful of cases, whether it's Hernandez v. Texas or some others that deal with Latinos and civil rights. This is predominantly history in terms of Cesar Chavez, but he did work to try to help sort of pay equity and general labor issues with farm workers predominantly. Immigration, and we generally throw immigration in with Latinos because obviously they're the highest impact of our immigration. But that's become sort of a predominant issue. One, there's a sort of disconnect, or there's a lack of clarity as to what rights immigrants have, and specifically more in particular, what illegal immigrants, right, or unauthorized immigrants, or undocumented aliens, or whatever term you want to use. What is their sort of legal standing, and what civil rights do they have? And so, for the most part, illegal immigrants get to go to public school, but there's some issues as to whether or not they fall under the citizenship clause of the 14th Amendment. If they don't fall under the citizenship clause of the 14th Amendment, are they afforded the protections in the Constitution? Theoretically, interpretively, Dred Scott was not a citizen under the Constitution, and therefore he didn't have legal standing under the Constitution. The 14th Amendment makes Dred Scott a citizen, but it does not make illegal immigrants citizens of the United States, and theoretically, therefore, they would not have the same sort of protections. And that being said, obviously, we don't deny illegal immigrants their ability to worship as they see fit, but they might be denied, warrantless searches and seizures, or they might be subject to warrantless searches and seizures. And obviously, there have been means of trying to curb illegal immigration, and so there's a handful of ways to go about trying to do it. But what you need to understand is we're on our third president of the 21st century, and basically all three of them have looked into trying to fix our system, our immigration system. Both Bush and Obama basically said we're a country of immigrants, but our immigration system needs fixing. Trump obviously has talked about trying to build a wall. Both Trump and Obama stopped or put a travel ban in effect for certain regions of the world. So there's obviously a lot of issues around illegal immigration in this. Now, I'll tell you this. So Trump's Muslim travel ban, which is what the textbook sort of declares it. It's not a Muslim travel ban. It was 6 nations, 5 of which were predominantly Muslim, but there are dozens of other nations that are predominantly Muslim that were not in the travel ban. There was a similar travel ban under President Obama that was not ever sort of deemed to be unconstitutional. If Trump's ban were solely on the grounds of race, it certainly wouldn't be permissible constitutionally. However, the Supreme Court allowed that ban to remain in place in large part because it sort of decided along partisan lines for the most part. Asian Americans and civil rights, again, a lot of this is historical. You go back and you get Chinese immigrants coming to California in the 1850s. They were highly discriminated against in California. You had like Chinese Exclusion Act that prevented workers from coming. You had a congressional declaration that said Chinese immigrants aren't eligible for citizenship. Ultimately, you get to the United States via Wong Kim Ark, And that creates the concept of sort of birthright citizenship. As Wong Kim Ark was born in the United States, he left, returned to China for a while, and then came back. And the Supreme Court would not let the United States deny him entry. Japanese immigrants obviously faced some civil rights struggles predominantly during World War II. A number of them were forcibly removed from their homes. They were put in really what can only be referred to as a concentration camp. You ever see the images are relatively similar between sort of the Japanese internment camps and Nazi concentration camps. And Korematsu of the United States in 1944 actually deemed this action to be permissible, which is a little problematic. Native Americans and civil rights is a little bit of a complex issue, just because Native Americans were not always subject to the laws of the United States. They were actually, there were instances in which natives were given more control over their land, or that their land wasn't necessarily deemed to be governmental land or national land or land of the United States. And so the history there is fairly problematic. Now, as it pertains to sort of civil rights, there is a fair amount of autonomy that Native Americans have on their sort of tribal lands, what they've been left with to this point. Disabled Americans, obviously, they want equal protection under the law as well, and so they want to make sure that there's no discrimination against individuals with disabilities. The ADA in 1990 is one of the predominant pieces of legislation that aims to correct that and make sure that public buildings have wheelchair access, and that the disabled or the handicapped or whatever the politically correct term is these days, that they're not discriminated against in terms of employment or healthcare, things of that nature. LGBTQ, obviously they've struggled for civil rights as well. The really sort of birthplace of the civil rights movement is the Stonewall riots in 1969. Over the course of time, there has been some movement, some gains. In the 1990s, Don't Ask, Don't Tell was put into place to allow gay Americans afford gay Americans the authority to serve in the military. They had previously been denied the ability to serve in the military. Don't Ask, Don't Tell simply meant that if they wanted to serve, they had to be closeted, but their command couldn't ask questions either. So that lasted for a little less than 20 years, and then the Obama administration overturned that. And the Obama administration allowed for the open serving of homosexuality or homosexuals. So now you can have gay marriage and be in the military. Some other instances, Texas v. Lawrence for an example. Basically, there's Texas law criminalizing intimate relations between same-sex partners, and that's overcome at the Supreme Court level, which goes into a whole bunch of different issues as to privacy and to equal protection under the law. And then same-sex marriage, sort of similar concept. So again, the concept here is equal protection under the law. So they want to ensure that all of those provisions that go to straight couples can go to gay couples as well, such as survivorship benefits, to retirement accounts, survivorship benefits as it pertains to child rearing and all things of those natures. And Obergefell v. Hodges is the Supreme Court case that ultimately overturns that. It was a 5-4 case with Justice Anthony Kennedy, who was a true swing vote at the time, siding with the liberals in basically finding that state laws defining marriage as a joint union between one man and one woman were unconstitutional. All of this brings us to affirmative action. And affirmative action is basically an attempt to overcome historical discrimination through, for lack of a better term, discrimination. So trying to equalize opportunity by trying to increase minority opportunity. So it's trying to fix past injustices by creating an avenue or an opportunity for those marginalized individuals, those marginalized members, to have more opportunity. Regents of UC v. Bach is probably the most widely known, although there's been a number of cases. There's a case for Michigan that's, I think it's Guttinger. There's Fisher v. UT, the University of Texas. There's been a number of them. But ultimately, what the court has sort of held over and over and over again is that affirmative action is okay. It's okay to allow for racial diversity or to have racial diversity play a role in issues. It's okay for schools to seek out sort of varying opinions. And the reality is that's probably an important thing, just because there's a concept in sort of democracy and whatnot called the marketplace of ideas. And so the marketplace of ideas basically says that the more sort of ideas that you have, the more exchange of ideas amongst the people, basically the better off it is for democracy and for the well-being of the nation and whatnot. So diversity of opinion comes from sort of general diversity. So race can be an admissions factor, so long as it's not the sole admissions factor, or so long as there's not like specific quotas. You can't say, that definitively, a definitive number of blacks or Asians or whomever has to get in. And the court also says that the burden of proof falls on the defendant, meaning, so if Bach is arguing that if Bach is arguing regarding hold on, sorry, I got a little sidetracked. All right, but anyway, so Bach is the idea that the discrimination has to you have to be able to prove discrimination. Again, so Grutter v. Bollinger, that's the I think it's Michigan's Michigan University, and then Fisher v. Texas is another one. Again, basically upholding this sort of concept that affirmative action is acceptable, provided it's not the only issue. All right, and so this takes us to the end. So this is everything that we needed to get through. Just took a couple of more minutes. All right, so thank you very much for bearing with me. I appreciate that. I'm gonna get these added together, and you should be able to get the quiz done this evening. Thank you.